The House Judiciary Committee this Friday morning, January 30th, and we're turning to some additional testimony on H578, animal cruelty bill, and can hear from Judge Zone first. Thank you very much for being here this morning.
Good morning. Thank you. So, Tom Zone, Chief Superior Judge. I have taken a look at version 1.1. I believe that's the most recent version. All right.
Yes.
So, if we go to the first section I'll talk about is, if we go to page 11, at the bottom of page 11 on line 18, this subsection begins to talk about a petition for an order that the person be relieved of the prohibition, that they can't possess pets. If you go on to page 12, line 5, it says that the court shall grant the petition without a hearing if neither the state's attorney nor attorney general files an objection. It then says if the court grants the petition, the court shall make findings and issue an order in accordance with this section. The court can't make findings about the appropriateness of granting it if it's essentially a default. And so if the intent here is that the court shall grant it, then it should just say the court shall grant it and issue an order. It shouldn't have language about issuing findings. The only finding would be is nobody responded. I would note that it's a policy decision for the legislature to have that type of shall, because if the court imposes this, let's say at a sentencing hearing, if the state doesn't ask for it or the defense doesn't ask for it, what this does is it provides a mechanism for the parties to essentially change a sentence over the authority of the court to keep it. And in contrast, with the section I believe you may have heard about yesterday for reinstitution of firearms, the certificate for being able to have firearms, that has a may in it as opposed to a shall. And so, again, policy, but you may wish to say the court may, because the court may have reasons it wants to bring the parties back in. And
right. So that'd be line 5, changing the shall to may.
Yes, that should work.
And striking the need for findings in that particular scenario. Yeah, that makes sense. All right.
On page 12, lines 14 and 15, actually line 15, it should have the word or after the word offenses, I believe. Whether the person committed any subsequent animal cruelty or other criminal offenses. This section, next section 3, when the court is considering whether or not to lift the prohibition from the order, it says the court may consider factors. It is questionable whether these factors are intended to be exclusive or non-exclusive. And so if the intent is to have them as non-exclusive factors, you may wish to have the lead and say may consider any relevant factors, including.
Yeah, it's interesting because Eric Fitzpatrick suggested that isn't exclusive, but the fact that I looked at it and was questioning, I think we may as well be clear about it. Any relevant factors, including.
Yes.
Right. Okay. Makes sense.
If you then go to subsection 4, page 13, line 1, again, the word shall grant a petition if it finds petitioner has demonstrated. If you're comparing this to, again, 13 VSA 8011, the court may. The court maintains that discretion.
Right.
I would also note that subsection 4 on page 13 is really the ultimate issue. They're not going to do something to animals again. It's likely it's not going to happen. And if you compare this to 13 VSA 8011, there are, I'll say, subsets. They're not saying the person's not going to go out and commit the crime. It's you're looking at other aspects of it, making specific underlying findings. And so you may wish to take a look and are we really intending the judge to have to be the soothsayer and predict that
Right.
it's no longer likely, or are we having the judge find that these factors are there? And I would suggest taking a look at 8011 just to get an idea of how it's structured for firearms may be helpful.
Yeah, that was flagged with to us yesterday. The no longer likely to abuse is we do need to do some work on it. Any other suggestions other than looking at 8011 factors?
I think if you look at 8011, you would be able to tie it into some of the concepts that the policy seems to effectuate about what you're really looking for the judge. You know, there's been no evidence of this. There's no evidence of that. Things like
Right.
that.
Is that Title 13?
It is
80
Title 13,
right.
8011, correct.
Thank you.
Page 13, line 5. It says the court shall enter an order declaring that the order prohibiting the person from owning, possessing no longer applies. You may just say the court shall enter an order vacating. Just a little simpler. The order saying that they can't have it.
Vacating the order. Yeah.
Yes, that should work.
It's that, right.
Page 13, lines 8 through 10 talk about an appeal to the Supreme Court. Lines 9 and 10 say the appeal shall be on the record and the Supreme Court may review the record de novo. You don't need the second half of that sentence because there's no record de novo review. They're inconsistent concepts. De novo means a new trial or new hearing, and on the record means you don't get a new hearing. So if it just says the appeal shall be on the record, that's fine. That's what it would be anyway, absent specific language saying it was de novo, but I would delete after the word record. Page 13. Page 13, line 11 through 13, section 7. It gets a little wordy and confusing as to what is being stated here. You may wish to take some guidance. The intent seems to be that if someone files a petition, they can't keep filing successive petitions. If you look at Title 13, Section 7605, which addresses the sealing petitions, it says if a petition for expungement or sealing is denied by the court pursuant to this chapter, no further petition shall be brought for at least 2 years unless a shorter duration is authorized by the court. And so that type of language, I think, would be a little clearer. It also leaves open that if someone appeals and the Supreme Court were to issue a different order, that order may impact when someone can refile.
Yeah.
Then we can jump ahead to page 17. And this is where we start having a lot of words about dates and times and 10 days and 5 business and this and that. And I did hear yesterday Chair Lalonde say, what about 14 days instead of 10? And I believe if I was on the Supreme Court, my response would be, I concur. That may be, certainly it's a policy decision, but if you went to 14 days, day is a day, under the rules of civil procedure, that would work. Speaking of rules of civil procedure, if you look at lines 10 and 11, on page 17, it says the computation of the 10-day period shall include the day on which the animal is seized. That's actually not consistent with the rules. The rules exclude the day on which you start. And so it would start the next day. And I think it's easier to stay with the rules.
So we're going to probably be changing that anyway to upon notice being effectuated or something to that effect. It's not the seizure, but it's the notice that is when the computation starts.
Okay. And so that may shortcut what I was going to say next. If you go to page 18, there's quite a bit of interplay between you have 10 days to file the request. And then if you don't file a request within 10 days, on the 10th day, the court has to it shall issue a forfeiture. Well, I don't know how you can issue the forfeiture on the 10th day if the 10th day they still have a right to file. And so there's an inconsistency there. So I will stay.
What line is that? I'm sorry.
it says, if you look at line 3, concerning the
Okay.
seizure, and that failure to do so within 10 days will result in forfeiture. And then there's other language on page 17. If you go back up to line 7 and 8, title to an animal seized pursuant to subsection B shall be forfeited pursuant to, but 10 days after the seizure if the procedures are followed. And so you're setting up a 10-day for both events. Also,
Okay.
there is a provision later on that talks about someone not having to post security if there is a hardship. This, however, sets up under line 6 and 7 on page 17. It says they have to request a hearing and post security within the 10-day period. But there's no indication of how they know what the amount of security is. There's no indication of how the court would have proceedings to determine whether there's a hardship within that 10 days to waive the security requirement. And so that would need to be fleshed out more on how that's going to operate.
Right. So it could be, and if we had just a post security of a fixed amount, would that resolve that?
Well, but they still would have, how do we know that they're getting notice of what the fixed amount is?
That it would be in the notice, presumably.
Oh,
Yeah, I
I'm
mean,
sorry.
if we,
You
yeah,
meant
no, I'm just saying that, yeah.
in
if
the
we put
notice.
it-
I apologize. Yeah.
Right, but it still doesn't give the opportunity to waive the amount. So we still have to figure that out.
And that, if you look at the current statute, it talks about having preliminary hearing, things like that. Anytime you're tightening up the timelines to try to move things along quicker, it provides an opportunity for those types of notices and those types of steps to be rendered difficult to put in. If you had a preliminary hearing, that's something that could take place at the prelim. If you have a preliminary hearing within X days, 21 days, there's no question at that hearing, it says, okay, look, you got to post this, you have to do that. And so those are policy decisions for how you want to structure it, but they would provide some clarity and guidelines for the individuals as opposed to saying, here's a piece of paper and it tells you everything you need to know. Do it or here's the consequence.
But so question, so the preliminary hearing would be, in your view, wouldn't be the full-on hearing on whether forfeiture should happen, presumably. I mean, because we say that that's within 30 days. Yeah.
Yeah. Because you have, think of it like a civil suspension for a DWI under Title 23, Section 1205. You're served the notice. You have a set time to file it. The notice itself tells you when you have a preliminary hearing. Yeah, it's within 21 days. The court then it's scheduled. The police know what days they can bring them in based upon the arraignment calendar. You come into court on that 21 days and you can, yes, I've received the paperwork. Any discovery, where do we stand? Okay, now we're going to schedule the final hearing and it's scheduled within 42 days. And this year you're saying it's scheduled within 30 days, but it provides that opportunity to, instead of running to try to get somewhere, you get to pause and say, okay, here's what's happening. Here's how it's going to happen. And here's what the expectations are. And if they're not met, here's what the consequences are.
Or that's one option, or the other option is to not require the security until they have that hearing on 30 days.
Yeah.
I mean, if they want to compress everything.
Yeah. So that right now under 354 subsection E1 has the preliminary hearing. And so when you move away from that, there are consequences, if you will.
So would it be possible? I mean, anything's possible. would it be practical if we had a preliminary hearing 14 days and then presumably the forfeiture hearing 14 days after that? In other words, they're still within the 30 days that we've been hearing from other witnesses being important. That makes sense?
It does. Yeah, certainly anytime you have tight timelines like that, there's a consequence. And so we're a zero-sum game with time for
Right.
court days. So if we're told you have to do something, someone's going to get bumped. And what the legislature is saying when it sends us bills that say you have these tight timelines is this is the bill that takes precedence over the other cases. And so
Well,
if that's the intent, it will be effectuated.
although there is the escape clause of the time limits established in the section are not jurisdictional and may be extended by the court for good cause shown. And
We try, I will say that the court scheduling, I think theoretically can be good cause shown, but I don't think that it is our intent to ever say good cause is just that we're busy. In other words,
right.
there's got to be something more than just the court docket because we want to effectuate what the legislature, and if it's signed by the governor, what is intended by the bill.
Okay. Okay.
Page 19. Lines, it starts on line 6 and goes on. It says the court shall make findings of fact and conclusions of law and shall issue a final order within 5 business days after the hearing. So first of all, there's a lot of language in this bill about 5 business days, and we use, is that taken care of already?
Catching the 7 days. Yeah, I'm already catching those.
Yeah. All right, yeah. There we go. That works. But where it says the court shall make findings of fact and conclusions of law and issue a final order within 5 business days. Anytime you put in those time limits for what happens, the question is, what if it doesn't happen? So what's the consequence? Do we deny the forfeiture if we don't issue it within 5 days? Is that automatic denial? Animals go back, or automatic grant and they don't get the animals? In other words, when you put in a timeline and you put in something that says you shall do something, there should be a consequence. The absence of that, I would note, especially with people with decisions, people are saying, okay, they didn't do it. And if that's the policy the legislature wants to follow, that's fine. But I would suggest that putting artificial timelines on for the issuance of decisions. We've had cases recently down in Brattleboro, for instance, where there have been multiple days of hearings. And what you're essentially saying, if you say a judge that you expect decision in 5 days, is that judge has a busy trial coming up that's been scheduled for 2 weeks, and they get this hearing in. Do we cancel the medical malpractice trial that's had witnesses coming in from all over the country because the judge needs time to issue the 5-day decision here? I just think that you don't need to put in those timelines. We understand the importance of timely decisions, and especially when you have the financial implications and property rights here.
So promptly or timely, what's the better one in this particular instance? I know we use both those.
Promptly works, because timely would indicate that there is actually a timeline. We do have a 90-day rule for the outside for issuance of decisions. That's a policy, but I think promptly would effectuate that. Line, we go down now to line page. The language, line 19 on page 20. The rules of evidence shall apply except hearsay shall be admissible. You then have up above that on line 4, affidavits of law enforcement officers, and that's the current language, which allows certain affidavits. That's consistent with, again, civil suspension proceedings. But with civil suspension proceedings, it's very clear that they are summary proceedings, and the rules of evidence do not apply. Instead, there are, for instance, Rule 80.5 of the civil procedure says, hearings under this subdivision shall be summary proceedings. Evidence is admissible if it is a type commonly relied upon by reasonably prudent persons in the conduct of their affairs, and the Vermont rules of evidence are inapplicable except for the rules of privilege. And so when you put in language like this, the question is that what the intent is? To go to something in that direction, which is a summary proceeding, or is it to say they really do apply, but hearsay is admissible? Is there a reliability requirement?
I think at a minimum we were going to add reliable hearsay, but so is the option to, well, I guess, do we need to cite to the Rule 80.5? Is that the rule you mentioned?
That's for civil that rule is specifically for civil suspension for DUI cases.
Okay, all right.
But I just use that as a reference that how the legislature, when you've said summary proceedings in 1205, how it's been interpreted for the rules of evidence.
And is this considered a summary proceeding? That's of a different ilk, but a summary proceeding?
That's the choice for the legislature. Do you want it to be a summary proceeding?
Go ahead, Ian. Yeah.
Judge Zone, could it be? I don't really remember what the language is for like a 12D motion hearing where the state can rely on affidavits, but it still has the rules of evidence, presumably. You know what I'm talking about?
Well, yeah, 12D hearings under 12D, the state has to establish by substantial admissible evidence in a light most favorable to the state that it has each of the elements. But the question there is not whether it's admitted at the time of the hearing so much as it's admitted if it would be admissible at trial. And the rule specifically provides a state, as here, can proceed on certain affidavits. But the test is what you've given us here, does it show that it would be admissible at trial? And so in that situation, if there's an officer's affidavit and it contains hearsay, you'd need a statement from the witness, because if the witness came in and testified, it would be admissible at trial. 1205J, as in John, says that hearings under this section shall be summary proceedings. And so the legislature has been very clear when you want to have something be a summary proceeding to identify it as such. And so if that's the intent here, to not really have the rules of evidence apply, but have it in a different direction, you may wish to take a closer look at that.
Okay.
And there was the provision. Let me jump back up. I apologize. Trying to work off of some comments in the side electronically as opposed to writing it all out. There is language in here. I can't come across it right now where it says the Supreme Court has to issue its decision within 5 days.
Yeah, that one's got to change.
So I
remember. I can't have to find it yet.
So we'll get that out.
Yeah, it's on page 23, line 13.
Thank you. I haven't gotten there. That's why. I was thinking for some reason it was up above, but yes. Also, expedited timeline. Are you telling the Supreme Court that if it has everything else it wants this case put ahead of it, that we have I can
Yeah.
imagine a number of matters that
Well, maybe we're
could be
being a little
viewed
presumptuous there,
differently.
but
I think the court understands its obligation to address things in a timely fashion, and I just don't know that you need, it is on page 23, lines 12 through 14.
Yeah.
so please apologize to Chief Justice Ryder for our presumptuousness on that, if he ever has seen that provision.
I have not sent it to him, so I'll let him know that you have sent that message. So
Or not, you can just let it,
You just let that one
No, we
fly.
can let that one go.
the only other comments I had were, when you're looking at the security provisions, if you look at page 23, it talks about the court collecting it. I would suggest the court be kept out of the collection business here. The payment should be made directly to the Director of Animal Welfare, or whoever, someone there. Think of it like child support. The legislature has put in a statute that unless the court finds good cause, the money goes to it goes to OCS in a child support order. OCS takes care of it. The court doesn't get the money coming to us and then send it along.
Right.
This should just go right to them.
Yeah.
But those are the comments I have at this time.
Martin, can I ask one question?
Yeah, please.
Hey, Judge. So one other question I had was, if we're going to go down the preliminary hearing route, so your example of like the civil suspension hearing for a DUI, it's like in my experience, the civil suspension almost always gets runs. They waive the timelines and they run it with the criminal case. In the language we have here, would they be able to, like, for good cause shown, essentially do the same thing if there was a underlying criminal matter happening at the same time as civil forfeiture?
In theory, yes. The court, there's one of the reasons I think moving it out of the criminal division was to afford the ability to move the case forward in a more timely fashion than to have something like that occur. And you're exactly right. Oftentimes what we see in a civil suspension is, well, there's a criminal, let's tie it all together, and therefore the civil, which is intended to move quicker, is going to be delayed by the criminal. It is very clear that the legislature, by putting this in the civil division, separating it at least division-wise from the criminal, does not want that to happen. And that is the way it would go forward. Does that mean there may not be times a judge may say in certain circumstances that there is good cause for delay? Sir, that can happen. But the inclusion of the language here that talks about essentially immunity, and that you cannot use what happens in the civil case, is a recognition that it's supposed to keep going. And so while, yes, it theoretically could be a decision by the judge, that would not happen unless the state and defense have an opportunity to fully and fairly advise the court of their assent or objection. And when we look at the state, my thought would be that if the court is being asked to delay something, the state, through its victims advocates and its work, would be able to find out from the animal welfare agencies what is their position. And so all that would come to the court in making that decision.
Okay, thank you.
Any other questions for Judge Zone? So we'll probably have another revised version of this sometime later next week. We'll give you an opportunity to, if you want to weigh in at that point.
Thank you.
That probably looking at Thursday next week to give our legislative council time to work on
We
this.
appreciate it. Well, thank you. Have a great day, everybody.
Yeah, thank you very much for your time. Have a good weekend.
Thank you.
You too. Take care.
Attorney McManus, if you could join us. Thank you for being available.
Happy to be here. Good morning, everyone. For the record, Kim McManus, Department of State's Attorneys and Sheriffs. Fortunately, you have heard directly from two state's attorneys who have practiced in this area, and they gave you both of their impressions of the first bill as introduced and then the revised version. I only have two comments to add at this point, and then we'll reserve any additional comments for the next draft, as I know you're noodling through a lot of the logistics of this new forfeiture hearing setup. First comment for state's attorneys and deputy state's attorneys who have been involved in these cases. I would be remiss if I didn't say that an overwhelming comment that I received back when looking at the first draft is that they do not see a distinction between sexually assaulting an animal, whether it's in front of a child or not. They, of course, appreciate that in front of a minor, it is a felony, but broadly, and I can't say the entire department because I did not survey the whole department, but of the DSAs and SAs that I reached out to, who I know have particular experience in these cases, their feedback was that sexual conduct with an animal in and of itself should be considered a felony. So I just state that for your consideration. The second one is more of a logistics piece, and it's page 27. At the bottom of page 27 on line 14. And this is regarding any funds that are have been deposited in the court, or as whether it's the court or animal welfare services, whoever's been holding the money. If there's money remaining, that the money is released upon the disposition of the related criminal charges. And we wanted to point out that once that civil forfeiture hearing process begins, that is then a separate process. And there may be times where the criminal case might be disposed, but the civil forfeiture is still ongoing. So we think there needs to be language there to cover both, so that that money is not released too early if the civil forfeiture is not complete.
So where's that again? Can you, I didn't catch that.
Page 27, lines 14 through 16.
Page 20. So
Yeah.
this is one question I don't know if you have an opinion on this. We didn't ask, I guess I don't know if Judge Zoney would have had an opinion on this, but perhaps you all do. That all comes under the cost of care part of this bill. And one question is whether we need that at all, given the way we're trying to set up the forfeiture component, because that's to try to get the funds that are needed that are subject to cost of care. And in fact, I think there might be some confusion if there's two different ways that we're trying to pay for the cost of the care.
And they'll admit, yes, this is language that I believe was in the first draft without the cost of care piece. So I do wonder whether it was a little hard for me to follow the path of whether this was needed or not. But as it's written right now, it would be confusing if that money was released solely on the basis of the criminal case being disposed of.
Yes, if this stays, we need to look at that. Okay.
Those were the only two comments.
Wow, we waited a long time for us to get that from you, and I apologize for having kept on rescheduling you for that.
No, that is quite all right. And again, when we see the next revision,
Right,
we will.
right.
But overall, though, a general statement of support for this bill from the department. As you heard from both state's attorneys, these are cases that really, they're hard cases for our prosecutors, and they're ones that those who do them are very passionate about them. So they appreciate the efforts being made to try and shorten these windows of time, and especially the proactive seizure of the animals up front. That is greatly appreciated.
All right, any questions for Kim? Not seeing any. Thank you very much for that. And this afternoon we have witnesses. I'm going to really try to keep them at 10 to 15 minutes so we can get out of here by like 2:30-ish or 2:45 on the statute of repose